Okay, good afternoon, everyone. I'm going to wait just 1 minute and make sure everybody gets online here, so please just bear with me.
Good afternoon, Mr. Lilly. Can you hear us okay before we get started?
I can hear you fine, thank you.
Awesome, great, thank you so much.
Okay, it looks like we have everybody. For those of you who are going to speak, please, if you can, turn on your video. If you're just going to listen, audio is fine. So good afternoon. As you know, my name is Alan Lilly. I'm the presiding hearing officer of the State Water Resources Control Board's Administrative Hearings Office. With me running the hearing today from my staff, I have Skylar Anderson, Kyle Woldridge, Amy Blunk, and Nicole Mullen. And as always, I just want to say I really appreciate all the work they do. We all do it from remote locations, and they manage to run these hearings seamlessly. And I really appreciate it. I couldn't possibly do these proceedings without them. As stated in section 12 on page 19 of our March 24th, 2021 hearing notice, my office has not ordered a court reporter for this hearing. We use the Zoom video plus audio transcript as our official hearing transcript. The hearing notice did advise interested parties that they may order a court reporter, but I do not believe that anybody did that. We held our first day of hearing on August 6th of this year, and I issued a post-hearing notice and order for the order and notice of the supplemental hearing on August 9th. And this is the second day of hearing, which was specified in that notice. So I will ask the attorneys representing parties to first enter their appearances, and we can go from there. It looks like we have, is it Mr. Taggart for Trimont Land Company? Go ahead.
Yeah, good morning, Mr. Lilly. This is Tim O'Connor and Paul Taggart on behalf of Trimont Land Company.
Okay, and since you're and that's fine, your name tag just says Taggart and Taggart. So if I get the two of you mixed up, I apologize and please correct me. And then it looks like Mr. Cho, are you here for Northstar Community Services District?
I am. Good afternoon, Mr. Lilly. Austin Cho on behalf of Northstar Community Service District.
All right, and I see we do have several witnesses, but do we have any other representatives of any other parties who wish to enter appearances today? I do see we have Ms. Emerzian and Mr. Sahlberg from the Bureau of Reclamation. If both of you want to just observe, that certainly is fine. But if you want to enter an appearance, please just let me know now.
I don't think so at this time.
All right, thank you, Mr. Sahlberg. If something comes up, feel free to speak up. Anybody else, any other parties who want to enter appearances today? Okay, well, this should go fairly fast today. As a reminder, and I think you all have done this before, please do keep your microphones on mute when you're not speaking. That just avoids any problems with feedback. And we've all been doing this for a year and a half, and I know I still have to be reminded to go off mute sometimes. So if you're speaking and you're still on mute, I'll just let you know. That's certainly no problem. And as before, you all have this down. Please address me as Mr. Lilly and each other as Mr. and Ms. so forth. I do want to preserve some formality to the proceedings. Does anybody have any questions about the process before we go forward? It's pretty much the same as what we did before. All right, so the August 9 post-hearing order directed the parties to file additional written proposed testimony and other exhibits regarding several listed topics. In response, we have received a revised exhibit Trimont Northstar 28 and new exhibits Trimont Northstar 36 through 43. I think the hearing today can be fairly short. What it does need to cover are new opening statements, if any, by the attorneys, the witnesses confirming that their new written proposed testimony is their testimony, and then the witnesses and attorneys answering my questions, and then if there are any attorney follow-up questions, that's fine. Does anyone have any questions about this process before we go forward? Okay, hearing none, either Mr. O'Connor, Mr. Taggart, or Mr. Cho, does any of you want to make any kind of a new or supplemental opening statement for today's hearing?
Yeah, good afternoon, Mr. Lilly. This is Tim O'Connor, and I just have a real brief opening statement whenever the hearing office is ready to commence.
Please proceed. Thank you.
Sure, thank you. Again, my name is Tim O'Connor, and I am here with Paul Taggart from Taggart & Taggart, representing Trimont Land Company. And for our opening statement, we just sort of wanted to reiterate a couple points that we're pretty sure the hearing office is familiar with, but I personally would feel remiss if I didn't take the time to sort of touch on some of those subjects early on. Our clients have worked really hard over the last couple of months to put together the information that the hearing office is requesting. They've put a lot of time and energy into it. The experts have put a lot of time and energy into it. And one of the hurdles that we faced when putting some of these things together is, as the hearing office knows, the original requests were being made back in 1985. And the extensions of time essentially were the process to review those was initiated in 1986 and largely put on ice since that time. Since 1986, TLC or their predecessors have not been able to put much work into the Reservoir B, which we'll be talking about a lot today and was addressed in the testimony. And that's largely because those permits have continued to pen since 1986. And by their own terms, the facilities and the water use under those permits really couldn't be undertaken while we waited for a hearing. Along with that, some of the reporting guidelines have changed, and some of that is also listed in the evidence that was submitted today, and making certain data points from back pre-1985 difficult or impossible to find. TLC and NCSD have worked very hard to compile all that old information. They've reached back through 4 iterations of companies who have owned these permits and all the reporting and paperwork that they could find. And at the end of the day, there's just some information that simply doesn't exist. We believe, however, that some of the light assumptions that had to be made in the expert reports, as well as the evidence that is relied on in the expert reports, does show that the extensions of time and the change petition should be granted by the water board and should be suggested to be granted by the administrative hearing to the water board. That evidence is going to show that since 1985, the then owners who were pursuing these permits were doing so with diligence. They were building things like the initial reservoir, the Reservoir A, the diversion structures for Big Springs and Sawmill Flat, all the associated diversion structures, water treatment facilities, really everything that went into the foundation of the mountain as we know it today. And this Reservoir B that we'll talk about, this was sort of the last piece that needed to go in to be able to start on that certification path toward these permits. But like I mentioned earlier, that's largely been on ice since 1985, to no one's fault, of course. I don't want this to sound like it's a fault, but that's just the facts of the case as they exist. So we definitely invite any questions on the submitted evidence from the administrative hearing office. We would be happy to supply any additional information that the hearing office feels is still necessary if we reach the end of this hearing, and such evidence might help make a decision. So in closing here, we believe the evidence supports the granting of both sets of petitions, the extension of time and the change petition. So we look forward and appreciate the opportunity to present this evidence to the administrative hearing office.
All right. Well, thank you, Mr. O'Connor. Mr. Cho, do you want to make any new or supplemental opening statement today?
Thank you. I have nothing to add to Mr. O'Connor's statement.
All right, thank you. And Mr. O'Connor, just to clarify, and this was in your papers as well, it's maybe a nitpicky point, but it's an important one. The Administrative Hearings Office does not adopt any orders. Under Water Code 1114, all we can do, and what we do, is prepare proposed orders and transmit them to the board, and then the board considers adoption. But I don't want any delusions of grandeur here on behalf of my office. We have no authority to take the final action in this matter. But we certainly will prepare a proposed order and transmit that to the board. That's our statutory obligation, and we will follow that. But just a minor point. And I certainly do. I will just say, I do understand your discussion or description of what has happened or not happened between 1985 and the present. It's not every water right matter that comes before my office where there is an interstate dispute being involved and a new act of Congress has to be negotiated, and then I'll just say a fairly complex operating agreement among multiple parties also needs to be negotiated. So I'm certainly aware of the complexities involved in that process and why it took time. And I guess I'll just say the good news is we now are to a point where we can move forward, and certainly we will proceed with this proceeding and get out our proposed order to the board as soon as we can. And then under the water code, the board has a fairly limited time to act on that after we send it to them. So I think at least for this phase, maybe the light is at the end. The light at the end of the tunnel is getting closer. So anyway, just wanted to let you know we're on board on that. And of course, it makes it a lot easier when we don't have any protestants for going forward. So with that, just a reminder, it looks like we have just two witnesses, Ms. Walsh and Ms. Wagner. And I'll start with you, Ms. Walsh. And just as a reminder, you're still under the oath you took during the last hearing day, so I'm not going to re-administer the oath. And I'll just start with my questions for you. Is Exhibit Trimont Northstar 36 your written proposed supplemental testimony for this hearing?
It is.
Okay, all right, I won't say proposed. So is this in fact your testimony for this hearing?
It is.
Okay. And Ms. Mullen, if you can please display Exhibit Trimont Northstar 36 on the screen and go to page 4, I would appreciate it. I just have a couple of questions regarding the testimony. Okay, thank you. And if you actually, that's fine right where it is. Make it one notch bigger. Okay, good. Ms. Walsh, at line 8, the sentence begins, in the middle of the line begins, the anticipated project schedule, and this is for Reservoir B, outlined in the report projects that the reservoir could be completed in late 2028. For more detail, please refer to Exhibit Trimont Northstar 37. Do you see that testimony?
I do.
Okay, and then just if we can just put up, Ms. Mullen, please just put up Exhibit Northstar Trimont 37, and then I'll ask you a couple of follow-up questions about both of them. And when you get Exhibit 37 on the screen, please move to page 25. Okay, great, thank you. So, Ms. Walsh, this in fact is the anticipated schedule that's cross-referenced in your testimony for the construction of Reservoir B. Is that correct?
That's correct.
Okay, so my question is, basically, how firm is this schedule? You know, assuming that the Water Board approves the petitions that are the subject of this hearing, how likely is it that Trimont Land Company is going to be able to go through this process and actually complete this reservoir by this deadline?
Yeah, what I would say on this is that this is the proposed timeline submitted just in the early submission of the proposal for the feasibility study. So we haven't gone into deep detail around all the different components to hit the 2028 deadline. That being said, with the feasibility study, we have every intention, if the permit and extension is granted, to move forward with that study. In fact, part of what was presented by Auerbach was to install a gauge on the creek, and we have proceeded with that with Auerbach at this point in time to move forward with that gauge for this season, to demonstrate that we know that we need to get things moving to be able to hit this timeline here. I think additionally, what I would say is there are potentially components and unknowns against this timeline that we couldn't predict right now if we would be able to have full construction by 28 with so many unknown components that we just couldn't speak to today. But the intention is there to proceed with the feasibility study.
Okay, well, that's probably about as good of an answer as anybody could give under these circumstances. I certainly am familiar with the challenges of building new water projects in California. The follow-up question I have is, let's assume everything goes according to schedule and the reservoir is completed, we'll just say for argument purposes, on December 31 of 2028. Hopefully you can finish it before it starts snowing that year. How long will it then take to fill the reservoir and then to apply the stored water to beneficial use?
I couldn't speak to that. Right now, I don't know what that length of time would look like. We would certainly defer to the snowmaking team and to Auerbach to understand that timeline, Mr. Ledley, but it's not something I could answer with confidence today.
Okay, well, and obviously it's also going to depend on how much runoff there is.
Yep.
Okay. All right, well, that's fine. And that's, I'm not going to criticize you because I think that's probably about all anybody can say right now. I'll just note for your attorneys, Mr. O'Connor and Mr. Taggart, I'm a little concerned. I'll just say from my experience, and I did have many years of representing water agencies and private practice before the State Water Board. It seems like a fairly aggressive schedule. And as you, I hope if this board grants this extension and then another one is necessary, I hope it doesn't take you 35 years to get it the way it has for this time around. But I don't think that, I'll just say, I don't think there's anything I can do to include in my proposed order any kind of a longer schedule, because this 2028 was the deadline listed in the petitions, and with the petition for the change of this one permit. And that's what is listed in the notice that we sent out to the interested parties. So unless I'm missing something that you're aware of, I'll just flag, I don't think we can put a later date in the proposed order, but again, flag for you and your client, if the board grants this extension, I'd certainly recommend you get to work right away, because if it comes down to needing another extension, I think the board's going to look fairly critically at the diligence between now and the end of 2028, and particularly if there's no impediment from a water right point of view to moving forward. I certainly understand that there are other permitting requirements and, of course, financing and all that. But anyway, just wanted to let you know, and I don't know, Mr. O'Connor and Mr. Taggart, if you have any comments on that before we move on.
I guess on that, Mr. Lilly, would be that we understand what you're discussing. I think we're in agreement that the petitions on file only request till 2028, but we understand what you're discussing as Ms. Walsh kind of laid out. This is the plan as we sit here today. We recognize it's it's a lofty goal, but it is an attainable goal according to the engineers that we rely on, and TLC is intending to proceed with this plan. So we appreciate the I don't want to call it an admonition from you, but I guess the
comments,
the information from you as far as the tightness of the timeline, and certainly they'll take it into consideration as we progress between today and 2028. And when we get to 2028, if there's no reservoir built, we'll proceed under the law at that time as necessary and as determined by TLC at that point.
Yeah, well, and again, I'm probably saying a lot more than I should, but I'll say it anyway. If you have a constructed reservoir by that time and you just haven't filled it and applied water to beneficial use, that's a pretty good exhibition of diligence. And if you need an extension just for hydrology purposes, that's something the board's going to be much more inclined to grant than if you haven't broken ground by that point. So anyway, just thought I'd mention that, and we can move forward. So thank you, Ms. Waltz. Those are all the questions I have for you. Before I move to Ms. Wagner, do any of the attorneys have any follow-up questions for Ms. Waltz?
None from TLC. Thank you.
None from me either, Mr. Lilly.
All right. All right. Thank you. So, Ms. Waltz, please do stand by. I think we're done, but just in case we have any follow-up questions, I appreciate it if you can stand by. All right. So we'll shift over to you now, Ms. Wagner. So, I'm sorry, Ms. Small, you can take down except that display, and let's just go to full screen for a minute. And then in a minute, I'll ask you to put up exhibit Trimont Northstar 38. So Ms. Wagner, you are still under the oath that you took during the last hearing. And I'll just start with my questions for you. First of all, is exhibit Trimont Northstar 38 your supplemental testimony for this hearing today?
Yes, it is.
All right, so Ms. Mullen, if you can please display exhibit Trimont Northstar 38 and then move to page 7 of that. Excellent, and then just scroll down a little bit. My questions concern paragraph 24. Okay, so Ms. Wagner, the paragraph 24 talks about the approved project and the components of the approved project. And the sentence I have a question about starts at line 11. And it says, and if you need to read the whole paragraph and take a minute to answer, that's fine. But I'm just going to read this one sentence. It says, however, because it lacks information regarding the nature of the water right permits and the changes sought in the pending petitions, NCSD has determined to prepare and adopt an addendum to the MWP update EIR. Can you just explain that? I'm not trying to be difficult here, but I just did not understand what you meant in that sentence.
The draft, the EIR for the master water plan update had a very brief description. Well, let me back up. It relied solely on the water supplies available for developing the master water plan update was developed using the existing water supplies available to NCSD and Trimont. And the basis for those besides groundwater were the surface water diversions that were all part of their water right permits. There was no discussion in the EIR about those permits. So they weren't actually, the amount of water that has been historically used and diverted and an average supply was assumed and described, but the basis for that wasn't. So there was no description of the permits at all in the EIR. And I felt that the EIR should include a description that this surface supply that the report is using to build its existing and future, water demand basis needed a description of the actual permits.
Okay, so I'll just tell you why I was confused, because now I understand what you're getting at. The problem was it. It says it lacks, and I thought it referred to NCSD, but you're telling me now it actually refers to either the 2002 MWP update or the 2004 EIR. Is that correct?
Correct. Let me just specify the 2002 update. It described the sources, the location, and what they were, the Big Springs, or Sawmill Flat Springs, but it didn't reference the permits, and the EIR did not have either description. So the it is referring to the EIR.
Okay. Well, thank you. Now that makes perfectly good sense to me.
Okay.
Yeah, okay. I don't want to be too critical, but it was confusing to me because the EIR is not actually even referred to in that paragraph. But now that you explained it, I get it.
Okay, then the master water plan update is the it in this.
Okay. Okay, got it. Thank you. So then, Ms. Mullen, if you can move to page 8 of this same exhibit. And paragraph 29 says here, I'll just read it, says this proposed CEQA addendum is still in draft form, but is expected to be presented to the NCSD Board of Directors for consideration approval at its November 2021 meeting. Is there a date scheduled for that meeting yet?
There is, I could defer to Mr. Cho, or I could provide that because I know that answer.
Better if you do, because you're under oath and he's not. Not
Okay,
that he would, I'm sure he would tell the truth, but just so our record's clear, you're the
okay,
witness under oath.
okay, it's November 17th at 9 a.m.
Okay. And okay, and obviously you can't tell me what they're going to vote because that's their discretion and they haven't decided yet. But and I do see if they do vote to approve it, then NCSD will file a notice of determination. So I will I'm going to make a note on this. I will circle back to this with you, Mr. Cho. I'll just tell you, I'm not comfortable sending a proposed order to the board without an adopted CEQA addendum, particularly when it's fairly, presumably, well, either the board will adopt it and we'll have it after November 17, or they won't and we have an issue for CEQA compliance. So either way, I need to know what happens on November 17 before I'm going to complete a proposed order and send it to the board. But we'll talk about that. I hate to say this, but I think we may have to have another supplemental hearing day, although it can probably be pretty short. But we need to get that final CEQA document into, and the NOD, if the addendum is adopted, we need to get those into the record. So with that, I can go forward to exhibit Trimont Northstar. Let me just see here. I think I want to go to 40. Yes, exhibit Trimont Northstar 40, Ms. Mullen, and then please move to page 20 on that exhibit. And I'm going to, yeah, my questions are, you make it a little bigger, but that's, oh, I'm sorry. This is a question of the page. If you can go to the next page, the numbered pages at the bottom are one off from the PDF page numbers. So I guess in the PDF file, it's page 21. There we go. But in the numbered pages, it's page 20. So Ms. Wagner, do you see the second paragraph on this page, which starts with TLC, the owner of permit 15905?
Yes.
Okay. The question I have is about the last sentence in this. It says, however, current requested actions of extending time to complete construction and beneficial use of the water under permit 15905 will not result in a physical change to the environment. Do you see that?
Yes.
And I'm wondering about this, and I'll just tell you, I'm skeptical about this statement. Maybe you can respond and either tell me why I'm wrong or potentially consider amending this before the board of directors adopts it. Because if the board denies the petitions for extensions of time, then ultimately the board will issue water right licenses. And you're familiar with this process. The board will issue water right licenses that supersede the permits based on the highest amount of use, technically before the beneficial use deadline, which was in 1995. Whereas if the board grants the petitions for extension, then the permittees may increase their diversions in use under the permits up to the full permitted amount. So I I guess I'm just skeptical of the statement, there's no physical change to the environment, because the board granting the petitions could allow a higher rate of diversions than would occur if the board denies the petitions. And obviously there could be associated environmental effects. So do you have any comment on that?
Well, sure. Largely, I don't disagree with what you're saying. The clients have already put to use over 1,206 acre feet of water in the project area. So while we're not contemplating above and beyond what has already been used, in addition, I think what I meant here is that this extension of time, it's a procedural change and not a physical change. So obviously there would be CEQA work probably necessary with building a reservoir, and any of those changes would be evaluated separately. Does that, I don't know if I answered your question.
Well, I think that explains what you said here, but I'll just throw this out, and you know, I don't want to belabor this or put you on the spot, but I do recommend that you consider discussing this with Mr. Cho, and consider, and I don't know where the district is in the process here. I'll just say I am a little uncomfortable with this. I mean, the water board, if the district adopts this addendum as CEQA lead agency, the water board as CEQA responsible agency basically has to accept that, except for some exceptions that I don't think would apply here. But I just think if you could edit that sentence before the board adopts this addendum to provide a little more detail along the lines of what you just said, regarding what the recent historical use has been. I know some of that's been from groundwater, and presumably there could be a shift over to surface water. And I just think having a CEQA document that explains this key point of environmental effects in more detail would be beneficial for the record here. So anyway, I'll just throw that out. It's up to you two to decide what to do, but it sure would make me be more comfortable going forward if we had some clarification on that language.
Mr. Lilly, would it be inappropriate for me to interject with a small comment on this as well?
You go ahead and make it. We're a little bit informal here today, so go ahead, Mr. Cho. You're not under oath, but go ahead and make your comments.
Sure. Well, I appreciate that. Thank you. I believe that sentence could probably be clarified, and it's my understanding that the intent of that was really to show that there would not be an expected physical change of the environment relative to the analysis already conducted, which did contemplate full build out of the permits. So I think that beyond the time differential, the temporal difference in what's being requested, there would not be a change contemplated under this project compared to what was previously analyzed under the master water plan. But your point is taken, and I think that sentence could be cleaned up a bit to get the point across that you noted and that Ms. Wagner clarified.
Okay, thank you. That is helpful about what's already been analyzed. And again, I'm looking at it from the water board's point of view, where I'm sure when this was drafted, it was drafted from the district's point of view, and they're both important. But I just do consider from the water board's point of view, granting the petitions does allow potentially more water to be diverted under the permits than denying the petitions would. So if that's already been analyzed in the EIR, great, but you just need to explain that here. So I just suggest the two of you work on that, since you do have time before the district actually acts on this document. Okay, anything else, Mr. Cho, on that?
No.
All right, thank you.
Mr. Lilly, I have a quick point of clarification on that, just to make sure I'm following here.
Please go ahead, Mr. O'Connor.
Would you like the petitioners then to resubmit a new version of Exhibit 40 to you? Or how would you like that to be handled procedurally if indeed we do decide to clean up some of the language?
Okay, yeah, you're getting ahead, but that's fine.
Okay.
What I plan to, the answer is no, they do not need to submit a new copy of Exhibit Trimont Northstar 40. But what I am going to ask is, at the end of our hearing today, I'm going to set a schedule for a new deadline for supplemental exhibits and then a new hearing date. And one supplemental exhibit I definitely want, if the district approves the addendum, is a copy of the approved addendum. And so I'm just suggesting to Mr. Cho and Ms. Wagner that they consider editing this draft before the district considers it. And then, of course, what we would get in the record would be the approved addendum, again, if the district approves it with the new language. So that would be the way it would get into the record. Does that make sense, Mr. O'Connor?
It does. It makes perfect sense. I appreciate that. Okay.
If you think I'm nitpicky, I am. I spent a long time defending administrative decisions in court cases, so I'm a stickler for having the best administrative records we can here. I think it's in all of our interest. Okay, so if we can go on to Exhibit Trimont Northstar 41, Ms. Mullen, if you can please display that. And when you, okay, great, thank you. And let's start with, if you can go to page 4 to start with, please. And scroll down below the table to the text at the bottom of that page. Okay, so Ms. Wagner, this is one of the technical memoranda you prepared and basically referred to in your testimony. And I'm trying to understand this, so bear with me. This is complicated. I think you've done a pretty good job of explaining it, but I just need a little more clarification. The first sentence here says, in order to answer the AHO's question of how the maximum increases in diversions and consumptive use that may occur if the state grants the pending petitions for extensions of time and change petitions will affect these California diversion and use amounts, surface water use from the annual inventory reports was updated to maximize NCSD/TLC diversions up to the full beneficial use of the face value of the permits, parentheses 1206 acre feet. Do you see that?
Yes.
And it says it was updated. I assume that means you made the change in assumption and then prepared subsequent tables with that change. Is that correct?
Correct.
Okay. So here's I'll just, if Ms. Mullen, if you can go then to page 6 of this same exhibit. Okay, and just scroll down to the bottom part of table 3. Looks a little bit farther down. That's good right there, thank you. So Ms. Wagner, the second to last row says, whoops. I'm always criticizing people for having phones that go off. I have one, excuse me. The second to last row says NCSD/TLC reportable surface water use % of total annual California allocation. Do you see that?
Yes.
Okay, and then here's where I was confused. For 2016, the number 1206.0 was entered, and that makes sense to me because you said on the previous, or on page 4, that your assumption, you were going to change your assumption to that full diversion amount. But what I don't understand then is why are the numbers less than 1206 for the subsequent years in this row?
Sure. Okay, so if you look at that year 2016, where we superimposed 1206, the full use, you'll see that snowmaking is non-existent in that year, 2016, in that column.
Okay, where is
So
snow?
just follow your eye upward.
Got
and
it.
you
I do see blanks there. Okay.
Okay, so in that year, all use was either municipal. We assumed we were going to stick with historical reporting, which it was described in the memo, but in 2016, when DWR prepared their annual use reports, they did not break out snowmaking based on from surface water or groundwater. And they did not allocate any depletion to surface water from snowmaking. So I made that same assumption for 2016. And therefore, when the full 1206 was put to use, it was either going to be municipal or irrigation. Now, when you jump over to 2017, 2018, and 2019, DWR in their annual reports broke out snowmaking as surface water and groundwater. And we know that Northstar does a good portion of their snowmaking from surface water. And then snowmaking's impact on the allocation that's allowed to California, there's a formula of how that's applied. And so they take off 225 acre feet of water that's used for snowmaking off the top. And that's both from groundwater and surface water. And then they have a remaining amount of water that was used for snowmaking, and 16% of that amount is what's counted against the allocation. So in this sort of theoretical model that I prepared for those 3 years, there will, as long as Northstar is using surface water for snowmaking, there will never be that full 1206 counting against the California allowable amount. Does that make sense?
Yes. The reason I was confused is that it's the term reportable. And based on what you're just saying, reportable is reportable under TROA, not reportable under the State Water Board's permittee progress reports. Is that correct?
That's correct.
Sorry if I'm slow here, but I'm learning.
No, you're good.
Well, no, but anyway. Okay, so that's why I'm just making a note here under TROA, not under, not to State Board, basically.
And it's probably worth adding, in 2016, there probably was surface water used for snowmaking, but rather than try to overcomplicate things, we just took the conservative approach that we were going to assume it was none. And so it gives a pretty wide range of the percent of the California, amount towards the allocation.
Okay, so that basically is the highest it could be under the 4 permits if the water board grants the extensions of time and the other changes, and then Trimont and Northstar were to divert and use the maximum amount allowed under the permits. And in fact, none of that, this is almost never would happen, of course, but then none of that was used for snowmaking, then these are the numbers that would be reported under TROA for the California share of the Truckee River Basin. Is that correct?
Correct.
Okay, so that's almost certainly, I hate the word conservative because it's not clear, what assumptions you're making or not making, but
right.
Basically that's an overstatement because the assumption of no snowmaking is not realistic. I mean, there's probably no way Northstar CSD alone could use that much water in the authorized place of use if Trimont Land Company was not using anything for snowmaking. Is that correct? I mean, the demands, I just don't think would ever be there.
I can't speak to that right now. The municipal demand is the projected, to be I think above 1206, but
Okay,
I don't have
okay.
those numbers memorized.
All right, then I better not jump to conclusions.
Yeah.
So we won't say this is not possible, but we will say this would be the maximum amount, and it would occur if none of the surface water diverted was used for snowmaking. We'll just leave it at that. Is that correct?
Yes, that's correct.
Okay, let me make a note of that. That is very helpful. Assuming none, no diverted water under permits used for snowmaking. Yeah, the TROA, I'll just say it's not simple. I mean, obviously, you read through and you begin to see why it took them so long to negotiate the whole thing. But that is very helpful, and that probably answers my other questions. But let me just go through them, because I assume that this carries forward. I had the same question. If we can go to Ms. Mullen, go to table 4 on the next page, page 7 of this exhibit. And just scroll down just a little bit more. Okay, so the depletion there in that last row, again, I assume the reason why it's 4882 in 2016 and then lower amounts in the other years is the same reason that the assumption is in 2016 there's none of the diverted water under the permits is applied for snowmaking. Is that correct?
Correct.
Okay, where in the other years the assumption is some was used for snowmaking.
Correct.
Okay, so your assumption is the diversions are 1206 each year, that there's a difference in the mix of purposes of use.
Yeah, if you go back to table 1 in the memo, which is page 3.
Yeah, Ms. Mullen, please scroll back to page 3. This is very helpful. So please take your time. Okay, and just scroll down. Ms. Wagner, tell us what part of table 1 you want us to look at.
Sure. Scroll down to the bottom, the last few rows where it says NCSD TLC use as a % of total.
Okay, there we go. Just scroll down one more click. There we go. Thank you.
Okay, so what I did is I calculated the % based on the historical reporting. And then I applied that same % assuming 1206. So that's why in 2016 of the 1206, 80% became municipal and 20% irrigation. And then the year with the highest snowmaking, which was 2018. So the 1206 was allocated under those percentages. And so we already had an amount that was used. And so all I did was increase the amounts to get up to 1206.
Okay. So then, hang on just a second. So for table 1, except for these are historical numbers which are used to calculate these percentages. Is that correct?
Correct.
Okay, so then if we go on to table 2, Ms. Mullen, please just go to the next page. In table 2, this is still historical, that you haven't put in the 1206 assumption yet. Is that correct?
Correct.
Okay, but then when we go to table 3, and that's where you have made that assumption.
Correct.
Thank you, Ms. Mullen. This is on page 6.
And in each use category, you'll see a additional for full beneficial use line or row. And that's the amount that we incrementally increased it by. So,
got it.
Okay.
That is quite helpful. All right, so now I'm starting to understand, but Ms. Mullen, please just scroll down a little bit. So now you've got to help me. Ms. Wagner has to help me. There to go. So then for 2016, the total reportable surface water use is 1270.9. You see that?
Mm-hmm. Yes,
So now why is that more than 1206?
that's the total reportable surface use under TROA for all users.
Oh, okay.
So
So there's someone
12
else in the Truckee River Basin using 64.9 acre feet.
correct. They're in Floriston downstream.
And that's the only other surface water user in the Truckee River Basin?
So this is sort of an evolving process, these reports, and they are definitely improving over time. But they're NCSD and Trimont are the largest users, and Floriston has a small water district, and otherwise they're very small, minimal surface water reporting, half an acre foot here and there.
Okay. I guess most use in the Truckee River Basin is from groundwater then.
Groundwater, yes.
All right, let me just write this down. I'm so glad I have a chance to ask you these questions so you can explain it. Okay, hang on just a second. I think that explains it. So again, for just while we're on this, for Ms. Mullen, just scroll down a couple of rows here. Thank you. So then for 2017, I guess it's the same thing. If I take the 939.5 for total reportable surface water use and subtract 871.4 for NCSD TLC's share, I can't quite do that in my head. It looks like about 60. Again, that would be the Floriston use.
For the most part, I noticed 2019, there were additional surface water, very, very small, but the report had a few more.
Got it. Yeah, if we get up to just over 100 acre feet for the other Truckee Basin users, is that correct?
Right.
Okay. All right. I guess nothing in water is ever simple, but thank you for your explanation. It's very helpful. But I have to try to turn this into a proposed order, so hopefully I'll get it right. But thank you for your explanations. Let me just check my notes here. Okay. Those are all the questions I have for Ms. Wagner. Do any of the attorneys have any follow-up questions for Ms. Wagner? Oh, and Ms. Mullen, you can take down that exhibit. Thank you.
No follow-up questions from Trimont. Thank you.
Okay, Mr. Cho, any follow-up questions?
No follow-up questions for me.
All right, thank you. All right, so let me just go forward here. Thank you, Ms. Wagner. For the attorneys, I have a couple of follow-up questions. Exhibit Trimont Northstar 42 contains the proposed new permit terms to implement various sections of TROA, which I, in my order, had asked you to submit. So I appreciate you doing that. And I see in there that there's some proposed terms for permit 15905 to implement certain sections of TROA that are not repeated in the proposed terms for the other permits. And I think that's because that's the only permit where there'd be a new reservoir. But other than that difference, I just want to check, are there any other differences in the text of the proposed terms for these permits, or is it basically the exact same language in all four of them?
This is Tim O'Connor for the record. I believe that other than the pieces that you pointed out, which specifically involve, features when you're building a new reservoir, all the other permit terms should be identical between the four. And maybe Mr. Joe can jump in if I'm wrong on that, but I believe that's correct. And the other piece that I wanted to point out for you, Mr. Lilly, and maybe this is where we're going, but Trimont Northstar 42 is those permit terms that we believe should be included in the permits. So specifically not included in term 42 is those permit terms dealing with a permanent organization to operate the reservoir. because we don't believe those should be included. So,
I'm sorry, I didn't hear that. You echoed a little bit. The permanent what?
so there are certain permit terms in this hearing that we've discussed revolving around a permanent organization. I believe
Right.
permit term 28, that is not included in those proposed permit terms because we believe that should not be included in the permits.
Right. I think, and that's in the present permit, and we're proposing. I asked if you wanted that deleted, and I think you're saying yes. Is that correct?
That's correct. And so I guess to put a bow on my point, Trimont Northstar Exhibit 42 is only addressing those permit terms which should be included. It does
Right.
not address all permit terms in question in the hearing.
Yeah, and I think your proposed order in Exhibit Trimont Northstar 43 addresses that point, so that's fine, and I appreciate that. I do just have one request, Mr. O'Connor, and that is if you can just email to the Administrative Hearings Office email address the Word file of Exhibit Trimont Northstar 42. It just saves us having to retype it if we're going to put that text into proposed permit terms.
Yeah, that should be no problem. We can get that off this
Yeah.
afternoon.
I didn't ask for it. You sent us Word files as a proposed order. I didn't ask for this before, but if you can do that, it saves my staff some time and it saves me the risk of making a mistake. I may edit it anyway, but I want to at least start out with your text. So
Sure.
Thank you.
No problem.
Okay, so let's just finish up our housekeeping here. Couple of other things to wrap it up. I appreciate all your patience this afternoon. I don't think we handled this last time. Mr. O'Connor or Mr. Cho, correct me if I'm wrong, but I don't think I asked you if you formally wanted to offer your exhibits into evidence. So this is a chance. Do you want to formally offer into evidence the exhibits from both last time and this time? And that's for exhibits Trimont Northstar 1 through 43. Either Mr. O'Connor or Mr. Cho.
Yeah, Mr. Lilly, that was my next question for you as well. We would like, petitioners would like to move into evidence Trimont Northstar 1 through Trimont Northstar 43.
Okay, and I assume Mr. Cho, you joined in that request?
Yes, thank you. And that is including the, I guess, errata to, I believe, Trimont Northstar in 28, which was just correcting some flipped pages.
Yeah, we'll just accept the new version of that. It was just moving the pages around to get them all in the right numerical order.
Correct.
So, okay, I'll ask, there's nobody else to object. So I normally ask if there are any objections. I'll say, are there any objections? But we don't have any other parties to object. So what I will do is I'm going to accept in those exhibits into evidence, except for exhibits Northstar 35, 42, and 43, because those are attorney submittals and no witness has testified to them. So we'll put them in the record for what they are. Essentially, they're supplemental briefing, but I'm not going to treat them as testimony. They're just, I mean, they were at my request, so there's no problem with your submitting them, and I appreciate your labeling them so we keep track of them. But I'm not going to formally offer those into evidence because they were not testified to. Is that acceptable to the attorneys?
Yes, thank you.
Yes, as long as they are part of the record, they can be referenced at some later date if need be. That would be fine.
Yes,
You know,
they can be referenced, but they're not going to be treated as testimony.
correct.
Or
Thank you.
as exhibits that were authenticated by testimony. All right, that will be fine, and we'll accept the revised version of Trimont Northstar 28 and not the original version, just because that's the one with the pages in the correct order. Okay, I do have one other matter before we get to the follow-up schedule. I was just this morning checking the draft water right permit 15905, and there's a term 14 which carries over from the existing permit, and I don't think we made any changes to it. And this is for the proposed new reservoir B, and it contains some bypass flow requirements that vary depending on water year type. And the water year type is defined based on the cumulative precipitation for each year at the Truckee Ranger Station. So this morning, I just quickly went on the web and searched Truckee Ranger Station rainfall records. And what I found, and again, this is attorney doing web searching, which in my case is dangerous, not necessarily accurate, but I found that the record stopped in 2011 for that ranger station. And I'd like to have, this is our opportunity to clean everything up and clean up 36 years of neglect. So I want to get this as good as we can. Of course, what I send is only a proposed order, but hopefully the board will agree to adopt it. But I'm wondering if either Ms. Wagner or Ms. Walsh, if one of you can look into this and see where the rainfall records currently, or it's precipitation, rainfall and snowfall records currently are being kept in the Truckee area, and if there's some new station that has superseded the Truckee Ranger Station, because I'd like to have the permit 15905 refer to the correct place for that. I'll just ask, does either of you know about that now, or is that something you need to investigate? Say it again. You have to go off mute, Ms. Walsh.
I was just going to say, I do not know, and hoping that perhaps Diane has some insight.
Ms. Wagner, any insight?
I can tell you that I can confirm there's fragmented data that starts and stops all over stream gauging and precip stations in Truckee. So I can get back to you and find one that's live and reporting.
Okay, I'm going to ask you to do a little more. You do such good work. It just makes me want you to do more. But please, if you can just prepare supplemental testimony, I think it's only a paragraph or two, but if you can just tell us what the historical record is of the precip records, where they were kept, for what years, and then also where they're currently kept, and then have a recommendation for what the permit term should refer to. That would be very helpful.
Just precip, not stream flow, correct?
Correct. Just
Great.
precip.
Okay.
Because that's what that permit term refers to. And the reason I ask for that going back historically is I would like the record to be clear in case anyone ever needs to look at this, as to why it potentially jumps between stations. If we have in our record what, our understanding of the historical record is, I think that would be helpful. And then, of course, we do want to have the permit term. I did put something in there in our draft that says if that station is not available, that then the permittee shall use the closest available, the data from the most closely available station. And we'll leave that in because clearly this could change over time, but let's try to get this as good as we can. Okay, thank you. All right, so then we'll move forward to a deadline. I would like to schedule a deadline sometime after November 17 for submittal of the following new exhibits, and you can just start numbering them with 44. And that would be the final CEQA addendum if it's adopted by the NCSD Board of Directors, and the NOD, which they will need to file with both the county clerk and the state clearinghouse because the State Water Board is a CEQA responsible agency. And then Ms. Wagner's brief additional testimony regarding the rainfall or the precip data for the Truckee area. So I'd like to set a reasonable deadline for submittal of those, and then a new hearing day. And I suspect 1 hour will be plenty for that hearing. But I don't know who to start with. I'll start with Mr. Cho and Mr. O'Connor. If you want to talk to Ms. Wagner, that's fine. If you want to take a break, if you need to, that's fine. But I would like to set the schedule now. Mr. O'Connor, you're off mute, so why don't you start?
Sure. So my initial thought is that as close to November 17th as we could get will benefit the parties, because as you mentioned, TLC proposed an ambitious plan in order to build Reservoir B. So we want this, essentially wrapped up as soon as we can, so that we can undertake those reservoir plans. So if November 17th, which I believe is a Wednesday, if November 17th is the date that we should have an answer back from NCSD, I would suggest, November 18th, unless anybody can jump up and tell me that cannot work. As far as the supplemental testimony, we should be able to put that together.
You're going to want a little more time, at least a few days, because you have to get the notices of determination filed and get date stamped copies of them from
Okay.
both the county clerk and the state clearinghouse. And, we're not going to have a hearing the following week anyway, because that's the week of Thanksgiving. So here's what I propose, unless Ms. Wagner cringes. She's the one who has to do the work here. But it's November. We can make, I'd say November 24th. Do you want, Ms. Wagner, do you want November 24th? Right before Thanksgiving, so you don't have to worry about it over Thanksgiving, or do you want it November 29th, so it's right after, or November 30th? You tell me what you want. But go off mute. There you go.
We're going to be in New York City on November 24th. So
Good.
it's not a great day, but the following week is fine.
Okay, let's set it, and I hate to set it for the day after you get back, but go ahead.
Monday, November 22nd, if that works for anybody, is fine. We leave Tuesday, the 23rd.
Okay. I'm going to do this. I'm going to set the deadline as November 30th, but there's nothing that stops you from filing these things earlier. A deadline is the last date. People often, I'm sorry, I shouldn't lecture to you, but attorneys often forget that. You can file it early if you want. But I'll set the deadline as November 30th for filing these supplemental exhibits. And then we do need to have a new hearing date in December. So, and Mr. Connor, I do appreciate your desire to keep this thing moving, and I want to keep it moving too. I like to get this one over to the water board because I have a lot of other things to be working on too. But let's target, let's see here, what's a good date? Right now, December 3rd looks good for me. That's a Friday. Does that work? I'd like to have Ms. Wagner and Ms. Walsh. Can you be available just in case something comes up? I don't think we'll need to ask any questions, but we might.
No problem. December 3rd looks good for me.
All right. And for Mr. O'Connor and Mr. Cho, does that work?
The 3rd works for me as well.
And Ms. Wagner, does that work for you?
The 3rd is fine. I just want to interject one thing. Does the date that the filing occurs affect the date of the hearing? Because certainly I don't want to be the one holding up the filing. I'll have everything done before the 24th.
All right. I'll put the 24th. I just want to have a few days to read them. But these aren't going to take very long to read. So
I'll have it all done. So I don't want to hold anybody up.
Okay, let's make Mr. O'Connor and Mr. Cho is November 20th. I've never had anybody ask me to make a deadline earlier before, but that's fine. Is November 24 a reasonable deadline?
I think it should be doable. I do appreciate your concern on getting those conformed copies for the filings of the NOD. I believe the district is fully capable of getting those out as soon as possible, but it may take a couple of days to get those conformed copies back. I think the 24th should work.
I'm going to just make it the 30th. It doesn't matter to me. And if you file them early, I won't criticize you. I'll be happy. I do want conformed copies, particularly of the NOD from the state clearinghouse, because that's a CEQA responsible agency. The state board needs to know that there's been that CEQA compliance. So we'll make it November 30th, and we'll have the hearing be December 3rd, and is 9 a.m. okay for everybody to start at 9 a.m. in the morning?
That's good for me.
Okay, Mr. O'Connor? You have to go off mute, though.
That works for us as well. Thank you.
Okay, I will try to hammer out a post-hearing order, which will be fairly short, and get that out tomorrow if I can. But with that, I think we have a fairly clear game plan here. And I do appreciate your patience bearing with me, although I think it's in all of our interest to have a complete record here. And particularly the board wants to have a complete CEQA record. As a CEQA responsible agency, the board wants to make sure that there's been a CEQA compliance. So that's why I want to go through this trouble to do that. Okay. Anything else for today? Does anybody have anything else they want to address today?
Maybe a foregone issue, Mr. Lilly, but if the district is able to supply its approved addendum and NOD, is there? I guess I'm just trying to gauge the hearing office's desire or need for a third hearing. It's a matter of accepting that document and adopting the approved order. That proposed order.
The reason is I want to have Ms. Wagner's testimony under oath, and it's just so much easier for me to do it this way rather than through declarations or something. So if you can bear with me, then I have a good, solid, clean record. She can authenticate the addendum and NOD and also testify about the precip data and exhibits. And it's just, I'm sorry to burden you with the extra time, but it's just a lot cleaner to have it all under oath. So I'd like to do that on the 3rd, if that's okay.
I'm happy to meet with you, and I have no problem with that. Would it be beneficial? We've got Eric Martin and Joshua Detweiler here today. Would you request that they attend the 3rd hearing as representatives of the district, or would Ms. Wagner's testimony be sufficient for the NOD authentication?
Yeah, they're certainly, Mr. Martin and Mr. Detweiler certainly are invited to attend, but you do not need to if you have some other schedule conflict. This is going to be pretty darn short, and it's your participation is not necessary. I mean, you have very qualified counsel, and Ms. Wagner will testify. And as I say, Ms. Walsh, just in case some question comes up, if you don't mind, but Mr. Martin and Mr. Detweiler, you do not need to participate if you can't.
Thank you.
Glad to have you if you can. Okay. Thank you, Mr. Cho. Anything else from you, Mr. Cho?
I believe you'll cover it in the post-hearing order, but my understanding is that the only additional documents that we'll be submitting are the CEQA addendum and the 2 notices of determination filings.
And the exhibits and written proposed testimony regarding the precip.
Correct, yes.
The Truckee River precipitation data. And I will list all those in the order. Okay, Mr. O'Connor, anything else for today?
Yeah, just a brief procedural question. And forgive me if this is written down somewhere. I just haven't been able to find it. When the AHO does make its decision on what it will send to the board, do the petitioners get notified of what that, maybe decision isn't the right word, but whatever the AHO proposes to the board, do the petitioners get notified of that? And what is that process?
That's a very good question. Don't hesitate at all. First of all, the document we will prepare is going to be called a proposed order. And my normal practice, which I will follow here, is I will prepare a draft proposed order, which will have all the findings and conclusions of law. And it also will have, assuming we go forward and conclude that the petition should be granted, it will have the proposed new amended permits, the 4 amended permits as exhibits, and probably some other exhibits. And my normal practice is to circulate that to all parties for their review and comments, just because, frankly, my experience is I usually get some pretty good comments. We do our best, but sometimes there are things we miss. And I'd like to get your review and comments and input in case there are any edits we need to make. And then after we've done that, then we formally transmit our proposed order to the board. And we also will include representatives of all parties as it's on the service list when we submit our proposed order to the board. So you'll know it when we submit it to the board. And then we send it to the clerk of the board, and then my staff works with her to schedule a board meeting date. The State Water Resource Control Board normally meets twice per month. And so we get on their calendar. Under our code, the board has to act within 90 days, so we do it as soon as we can. But it takes a while to get onto their schedule. And you will also get notice of that. And then, basically there'll be an agenda item, which will say something to the effect of consideration of Administrative Hearings Office proposed order on Northstar Trimont change petitions and petitions for extension of time. And then that meeting is run by the chair of the board, not me, but you certainly will have an opportunity to comment, to observe that. It's a public proceeding, and you can submit written comments in advance, although hopefully by then we will have addressed all your comments, and you can submit oral comments during the meeting. So that's our normal process, and I'm sure that's what will follow here.
Great, thank you. I appreciate that.
Yeah, we the board really strives hard to have an open public process, and as I say, I do as well. So we don't do very much under the table here. We do sometimes have confidential briefings of board members, which we're allowed to do, but other than that, everything's public. So, and if you have any questions as the process goes forward, I'm pretty rigorous on trying to avoid ex parte contacts. It's not as big of a deal here because we don't have any adverse parties, but still the best thing to do is if you have any questions at any time, try not to burden us too many, but if you do have questions, just shoot us an email and just include all the other parties and their representatives as CCs, and you can do that anytime. Then there's no concern about being ex parte. We can respond by email. We just make PDF files of the emails and put them into the administrative record. So again, it's all pretty public.
Great, thank you. Well, with that, again, TLC really appreciates all the time that the AHO put into this hearing and thoughtfully thinking through this. So thank you for that, and TLC has nothing further today.
All right, well, thank you all for your participation today and your follow-up efforts, and I'll plan to talk to you all on December 3rd. So with that, we'll conclude the hearing for today. Thank you.
Thank you, Mr. Lilly.
Thank you.
Thank you.